Good afternoon, everybody, and welcome to the latest in Fox-Williams Fashion Law webinars. Our webinar this afternoon is going to be looking at the intellectual property aspects, in particular, how to protect fashion trademarks and designs post-Brexit. It is the case that Brexit has thrown up a considerable number of issues for the fashion industry, but ensuring that trademarks and designs held by fashion companies are suitably protected, both in the UK and in the European Union, is critical to the success of many fashion businesses. Our speakers today are Simon Bennett, my partner and head of intellectual property here at Fox-Williams, and our colleague Scott Steinberg, who is one of our specialist IP associates. Without further ado, I will hand over to Simon, who will start our webinar this afternoon. And then after Scott has spoken, there will be an opportunity for you to raise questions. In the interim, please feel free to load your questions onto the webinar using the appropriate buttons. Simon, over to you.
Thank you very much, Stephen. And thank you very much for that introduction. If we can just go to the previous slide, I just wanted to outline the agenda for this session. Please feel free to use the chat function to ask questions as we go along, and we'll try and cover those as well in the presentation. So I think the first thing we wanted to look at really was the issue of how to protect the resale of UK fashion branded items in the EU, because that's one of the things that has come out of Brexit. And then we wanted to look at the question of designs, which is increasingly important in the fashion industry, and how Brexit has affected the issue of design right protection, both protecting rights in the EU and also protecting rights in the UK, but now that we're not all part of the same team, as it were. And then finally, we wanted to cover some sort of practical tips and what action you should be taking to safeguard your fashion designs and rights going forwards in this new world that we're living in. So I'm going to start by introducing Scott, who will cover the first topic, and then I will cover the second one, and then both of us will cover the third one. Over to you, Scott.
Thank you, Simon. So just to briefly start before we get into parallel imports, we should just quickly cover what a trademark is. So as it says on the slide, trademarks distinguish the goods or services of one company from those of another. And they come in a variety of forms. So we've given the Nike, Nike the word itself as a stylized word. We all know the sort of tick logo and the slogan of just do it. And word marks, and then you get protection for the goods and services that the trademark is registered for rather than everything. To sound like Chris Whitty, next slide, please. So trademark infringement, this is the law, the exciting part for us anyway. What is trademark infringement? It's where someone uses a sign that's identical with your trademark for goods or services that are identical to those you have registered, which is 10.1, or a person infringes by using a similar identical sign for identical similar goods, and there's a likelihood of confusion. Now, notice the word use in the course of trade there. So that's important for parallel imports because use includes importing or exporting. So if I have a UK trademark, for example, I can prevent someone importing one of my genuine goods from the US into the UK using my UK trademark. Why would you want to do that? Well, that allows me to, as a company, to set different prices for my goods in different countries. Goods may comply with regulations in one area, the USA obviously has different regulations to the UK. And so, those are sort of the reasons behind that. Next slide, please. So parallel imports and exhaustion. So this is the law pre-Brexit. You can see section 12 of the Trademarks Act is the UK version. The EU version is almost identical, or at least was. So it wouldn't be trademark infringement in relation to goods that have been put on the market in the EEA So this is wider than the EU. It includes, Iceland, Liechtenstein, Norway, Switzerland. Under that trademark, by me as the trademark owner, or someone I've licensed or given a distribution agreement to. However, that's subject to there being me not having legitimate reason to oppose that. So, for example, a poor version of my genuine goods. So what does that mean in practice? Pre-Brexit, it was not trademark infringement to import, further distribute, resell into an EEA state, including the UK at the time, my genuine goods that were put on the market under my trademark in another EEA state, as long as that was with my consent. As I said, unless there were legitimate reasons to challenge that. However, I could, in my earlier example, stop, the US, if the good was from the US, I could still stop that import. That wouldn't be changed. And so why does this exist? Well, we all know about freedom of movement in the EU, which is sort of a, underlying concept of the whole EU, that borderless trade, tariff-free trade. So this is sort of a way around the fact that trademarks are territorial. So that's why sort of exhaustion exists. But obviously Brexit has happened. So what has changed from 1st of January? Next slide, please. So the UK has decided, let's just keep the status quo. So if I put my goods on the market in the EEA for the first time, I will not need the trademark owner's permission or consent to then sell those genuine goods into the UK. Nothing has changed. Unfortunately, because of Brexit, the UK is no longer an EU member or an EEA member. Therefore, it's not reciprocal. So if I first put my goods in the market in the UK, I then need the permission potentially of the trademark owner to then to resell those goods into the EEA. And just to give you a practical example, say you have additional fashion stock that you have in the UK. Previously, no problem at all. I can resell my additional stock or, via Amazon into another EEA country or just generally into another EEA country. Well, that's not the position anymore necessarily, depending on where it was first put onto the market. And I think I'll hand over to Simon at this point.
Thank you, Scott. I'm going to have a quick look at design rights. So just a couple of pictures up here for you. We've got 3 slides now, a few pictures, which we'll canter through. These are examples of why we have design rights, and the critical thing about design rights is that there's an EU design right and there's also a UK design right, and the critical thing between the two is that the EU design right protects the sort of surface decoration of an item, whereas the UK right doesn't. So, for example, the Boohoo and Erica Cavallini dresses on the left-hand side of your screen, those are more likely to be protected by EU design right than UK design right. So, question there is, what happens now that we've left the EU? How do we protect those styles of items in the UK? So if you can just go on to the next slide, we can answer the questions as we go through. Again, some more examples here of designs that have been copied. Different items, different price brackets, and as you can see, some of the brands there wouldn't have been happy with what's been copied, allegedly anyway. If we go on to the next slide, we've got one more slide of examples, most importantly the handbags and others. Again, if you look at the Nordstrom and Goodnight macaron bag, again, that's an example of something that can be protected by EU design right, but not UK design right. So what's happened now that we've left the EU? So if we go on to the next slide, we can see what's happened. Effectively, what happened was that when we left the EU, the UK has now implemented a separate design right law which mimics or copies the EU design right law, which provides protection for for UK design rights in the same way that the EU design right protected designs. This is important because it then puts us on a level playing field, to use a familiar term, with our other European neighbours in protecting rights in this country for two designs, and particularly fashion designs, where this is a big issue. The problem that's occurred with this, though, all very well, is that what happens when you want to protect your UK design now in Europe. So we can easily get our UK design now in the UK, because we've got now the same law as the EU. We preserve that. But the problem we've got now is that under the EU regime, you have to first publish your design in the EU to get protection. So this means that if you publish your UK design now, if you first publish it in the UK and not in the EU, that means you will not get protection for your UK design in the EU. So that is a big issue, particularly for British fashion, where you might launch your product, say at London Fashion Week. What happens there? So the risk, the problem that can occur is that you've published your design in the UK, so you get your protection in the UK, very good, but you don't get your protection in the EU. So problem there. Now at the moment there's no sort of solution to this that's been sort of enshrined in law. But what the current thinking on this is that if we simultaneously publish both in the UK and the EU at the same time, and that's obviously being made more easy with online launches now, so we have the COVID pandemic to thank for that, that you could argue simultaneous publication, provided that the launches are directed at both the UK and the EU. So we would recommend that that's what you do when you launch a new collection or launch a new item, that you publish in both the EU and the UK at the same time, and furthermore that you can prove that you've done that, so you keep a record of it, and we think that will constitute publication in the EU. But as I say, it hasn't been judicially tested yet, so there is still scope for maneuver there on both sides, depending on which side of the fence you're on, in terms of protection. If you can move on to the next slide. On registration, there's also registered designs. So what I was talking about earlier was unregistered designs. It's also possible to register your designs, and that's the preferred option if you can and if you've got the money. It's not as expensive as you think. You can now register your designs in the EU and UK, and any EU designs that you hold, any EU registered designs, and have been automatically cloned as UK designs. So that's good news there. So if you do have an EU registered design, you will find that you also now have a UK registered design. The bad news is that going forwards, if you want to protect your designs in Europe and the UK as registered designs, you have to file in both. You have to file 2 registrations now rather than 1. That's a sort of short sort of canter through designs, and particularly registered designs. If we go on to the next slide, we'll look at what businesses should be doing, and maybe I can hand you over to Scott for the trademark points, and then I can cover the design points after that.
Yeah, sure, that's fine. So yes, certainly review your trademark portfolios. If you had an EU trademark before, you should have a cloned UK mark nowadays if it was registered. But if there is a gap, then that should be addressed as soon as possible. And then, yeah, that's the same point. The main point on exhaustion, I would say, is if you do have a sort of license or distribution agreement that allows you to sell in one territory, certainly look at the territories that you have permission for, and it may be that you need to ask for further permission. And as it says at the bottom, don't miss the deadline for any pending EU trademark applications to have those sort of almost copied into the UK, if you can call it that. Yeah, I think that's all from me, Simon.
Okay, thank you, Scott. Yeah, I mean, as I said before, on designs, the most important thing is to make sure that you now publish in both the UK and the EU simultaneously when you're starting to market your designs. So make sure you do that, and that should give you the possibility of having protection in both the EU and the UK, and that's for your unregistered designs, which you don't file, which arise automatically. You have to prove copying in order to succeed in proving infringement of those designs, but it does give you at least something to go on if necessary, to prevent copying. I think we've sort of come to an end there of what we had to say in terms of the slides, but as is the way with these things, it's always good to have questions and have a debate and discussion on some of the issues that we've raised. And so if there's anybody that's got any questions or comments, please feel free to raise a hand or put in the chat, and we can answer those.
Thank you, Simon, and thank you, Scott. It happens that we've got a number of questions which have already been asked by our audience this afternoon. So if you're very lucky, you'll avoid my hard questions. But let's start. Often it's the case that a website owned by a fashion brand is accessible to those who wish to view the website wherever they're located around the world. It could be said the website is global. Is that covered as publishing in the UK and the EU at the same time? If, for example, you would put a design onto your website for the first time? Simon,
sorry,
I think that might be for you.
Yeah, I think if I understand your question correctly, I think the issue is access. It's not necessarily where the website is located, whether the ISP or is based in a particular country, or the URL is a particular domain name. I mean, people can manipulate those quite easily, as we know. The most important thing is that the website is directed at the country in question. So if, for example, your website is purely UK focused and doesn't offer any sales outside of the UK and is simply directed at a UK audience, that will be obviously publishing in the UK only. If your website is directed also at Europe and has the ability to accept transactions through Europe, then it's more likely to be held to be publishing in Europe as well. So I think the key there is to make sure your website is focused on Europe as well as UK, and you don't just focus on the UK only. I hope that answers your question. I think you're on mute, Steve.
Thank you. Yeah, one of the perils of online webinars, yes. So I think that answers one of the questions, in fact, probably two of the questions we've had in. Another question, most interesting. This concerns simultaneous publishing. Does the simultaneous publishing idea take away the exclusivity of fashion weeks if collections are to be launched online for design right purposes? Or are we moving away from, let's call them physical fashion weeks anyway, with online events being so commonplace now? Thoughts? Welcome.
I suppose. Yeah. I mean, as I said before, I think we probably are moving away from physical fashion weeks, and most events are online. So I think that, as I said before, I think that's a benefit really for this on this issue, because if you can show, if we look at taking London Fashion Week as an example, if it's sort of attended by people online from Europe as well as the UK, again, I would say that's publication in the EU. So that's obviously a good thing for protection purposes. I'm I think I suppose it's a different question as to whether that takes away the exclusivity of fashion weeks. It may well do, but then I suppose you can still have exclusive events that are online and are only password protected or only available to invitees, just like the physical ones are. So I suppose they could be ring fenced in that way. But that's probably a question for the London Fashion Week's organisers.
Thanks for that. And indeed, I received a notification earlier this week that London Fashion Week and various other shows are going to be real events as opposed to online events. Anyway, let's move on. Next question. Are design registrations prior to Brexit still valid, or is it necessary to re-register?
Well, it depends on whether they will still be valid, provided they are that you've renewed them, or provided that so if you've got an EU registration, that will still be valid in the EU, and the EU registration will automatically have been cloned to create a UK registration. So I'd be happy offline to look into that for you if you'd like me to, and check whether your cloned registration has been created. But that will be still valid, and it's still valid for the same term as the EU registration. So yeah, the answer essentially is yes, and they are still valid.
Okay, thanks for that. Meanwhile, the questions concerning designs keep on coming. So next question concerns a design, an EU registered design, which was registered a couple of years ago, 2019. Has that registration been cloned so far as the UK is concerned, or should have been cloned?
Yes, yeah, the answer to that is yes. 2019, if it was registered, it will be cloned. It will have been cloned, or it should have been cloned to a UK registration. The thing with registered designs, you have to renew every 5 years. So if it was registered in 2019, your renewal date isn't until 2024, in which case it should still be valid, and it will be a cloned registration in the UK. Again, if you'd like me to do so offline, I can look into that, and I can, if you give me the EU registration, I'll find you your UK one.
Excellent. Excellent. It's the case that as a result of the COVID pandemic, both the UK and the member states of the European Union all have found themselves in a situation where they're running very significant deficits. So the inevitable question, costs of registering in the UK, in the EU, so far as design rights are concerned, and I suppose trademarks as well. Are we going to see an increase, for example, so far as the UK is concerned? Is this going to be a way for our Chancellor to ensure, case Tesco, that every penny counts?
I'll just quickly say that, as far as I'm aware, no, the fees haven't changed. But mainly probably because the UK IPO will get, that's the UK Intellectual Property Office, will get additional fees anyway by all these cloned marks, whenever they're renewed, that they wouldn't have had before. So all the EU trademarks that have been copied over, I assume that's where the UK IPO are probably budgeting to get some more money. So technically, there may be more fees, even if it doesn't change, if you have to renew a UK and an EU one, and that'll be the same for designs. But yeah, as far as I'm aware, the fees haven't changed at the moment, at least.
Okay, thanks for that, Scott. Meanwhile, Simon, any views as to whether a distinction can be drawn between a website which is used purely for marketing and a website which is a transactional website?
Thank you for that question. I think the answer is it's a question of evidence. So if you can prove that the site is marketing to the EU, and so if there are ways of doing that, so for example, language, using different, maybe there's translation of the site into French or Italian or whatever other European country might be marketed to. If you can prove that there is that sort of connection and that people are, I mean, it may be that you can do it by even just by looking at the number of hits you're getting on the website from people in other European countries. And so if you can show that you're getting a large number of hits, or at least, you know, more than just a small number anyway, I think from an evidence point of view, that in my book would be publication. And so that, yeah, but again, it hasn't been tested this, so you know, I can't say for certain what the answer would be, but that certainly would be my best guess on it.
Okay, thank you for that. And following on from that, an intriguing question: if a retailer in the EU has an online store and showcases let's say some shorts which on the face of it infringe a UK brand's UK registered design rights, and that particular online store of the EU-based retailer is accessible to view from the UK, is it possible for the UK brand to have to use that showcasing in order to claim infringement? Or is it a case of actual sales so far as the UK is concerned? And I apologise for the lighting, which is just affecting my screen at the moment.
I think again the answer to that on design, from a design's perspective, if you're making sales of a product in the UK that's protected by registered design, that would be an infringement. If the articles are only sold in the EU and they're not, you can't buy them in the UK, then that wouldn't be an infringement of a UK right following Brexit. The fact that they're accessible to view online, there wouldn't be an infringement if all you're doing is looking at them. That's different from the trademark position, which I'm sure Scott can elaborate on. But I think the issue of design rights is a matter of putting them on the market. So if you're actually selling them, so that's where the infringement comes in. Whereas if you're just offering for sale, that could be a consideration for trademarks. So I don't know if you've got any comments on that, Scott.
Yeah, it's similar to what we've been saying. So if you've got the comparable mark anyway in the EU and UK, you should be protected in both jurisdictions. And it'll be that test that we had on the slides before. You know, is it identical mark, identical goods, or similar mark, identical or similar goods plus likelihood of confusion? Because trademarks are territorial, so you only get protection for where you're protected.
Indeed, and just following on from that, and I think wrapping up, a question to both of you. Scott, you referenced reviewing your trademark portfolio. Do you ever come across, either of you, situations where brands that you act for have introduced new lines, for example, a fragrance line, and accessories line, eyewear line, footwear, and have sort of forgotten that whilst geographically they're okay in terms of where they're selling, actually they haven't got registration in place so far as the new line is concerned. Ever come across that sort of situation? Well, you're smiling, Scott, so I'll give that a yes. Yes.
I think we say a lot. Trademarks are often sort of a second for a lot of clients. Obviously there's business things that come first, but trademarks aren't necessarily considered before expanding a brand. And why would it necessarily be at the forefront? But it is incredibly important, because otherwise, someone could apply for that trademark before you, and trademarks are first to file. And yeah, that's less than ideal, let's say. I think I'll leave it there because I've noticed.
Okay, Simon, anything from you so far as that particular issue is concerned?
Yeah, I mean, I think as Scott said, I suppose it's cost benefit analysis, isn't it? So if you're looking at expanding your collection into other territories, it does pay to try and register if you can in the territories where you think that you're going to be selling, a significant amount. It is in fact possible to file what's called an international trademark application, which designates countries of interest. And that's a much cheaper alternative than filing in every country separately. So again, we regularly advise people on how to do that and how to also limit cash flow as well, cash outflow, I should say. When filing trademark applications, it is possible to stagger them and also backdate them at the same time. So again, that's another way of dealing with it, so that you can get the protection, but with limited cash outlay.
Okay, fine. Thank you very much for that, Simon, and thank you also, Scott. That concludes our webinar this afternoon, looking at the issue of protecting trademarks and design rights post-Brexit, both in the UK and in the European Union. For more information, please do visit our website, fashionlaw.co.uk. You will also find on your screen under the chat button the ability to subscribe to our mailing list for our monthly fashion focus and IP newsletters. But for the purposes of this particular webinar, thank you very much again, Simon and Scott. Thank you all very much for attending, and a good afternoon to you all. Take care, everybody. Bye-bye.
Thank you.